This syllabus extract outlines the core objective of our family law module, equipping you with the exact legal and procedural knowledge required to manage relationship breakdowns. The landscape of that procedure underwent a massive modernization with the implementation of the Divorce, Dissolution, and Separation Act 2020. Under the old system, couples faced an adversarial hurdle, forced to prove fault through allegations of adultery or unreasonable behavior. Today, that requirement has been replaced by a simple, non-adversarial statement that the union has irretrievably broken down. The vocabulary of the court has caught up to this reality. The spouse initiating the process is no longer a petitioner, but an applicant. And the initial hurdle of the decree nisi is now simply a conditional order. The most significant structural change is how these proceedings begin. For the first time in matrimonial law, spouses can apply to end their marriage either solely or jointly. Because the court no longer investigates marital misconduct, the regulatory friction required to separate two lives is now entirely embedded in the calendar. The Family Procedure Rules 2010 now function as the primary framework for managing the pace of dissolution, enforcing mandatory cooling-off periods to ensure these legal decisions are deliberate. Securing a dissolution requires strict adherence to a statutory timeline, essentially a legal Gantt chart of mandatory wait periods. We will trace this timeline from the absolute R on filing in year 1 all the way to the pronouncement of the final order. The modern practitioner's primary role is no longer to litigate past grievances, but to manage the sequence of deadlines with absolute precision. The procedural clock starts at day 0, the exact date the marriage or civil partnership is registered. Section 3 of the Matrimonial Causes Act 1973 prohibits any application for divorce within the first 12 months of that union. Civil partnerships face the exact same restriction under Section 41 of the Civil Partnership Act 2004. While you cannot start legal proceedings during this lockout, any events that happen during that first year are still legally relevant and can be cited as evidence of the breakdown once the year expires. Parliament designed this rule to provide a mandatory period of permanence, ensuring couples cannot impulsively dismantle their legal commitments immediately after making them. Unlike other waiting periods you will encounter in family law, this bar is absolute. The court has no discretion to waive it, regardless of the circumstances. This makes the 1-year bar the first non-negotiable procedural hurdle in the life cycle of any marriage or civil partnership. Once the 365th day passes, the initiation phase opens. Legal professionals now rely on a digital-first approach, filing applications directly through the MyHMCTS portal. As detailed in Section 4D, submitting a valid application requires 3 specific components: the Form D-8, the original marriage certificate, and the court fee. Section 4A confirms these applications draw their statutory authority from the Matrimonial Causes Act 1973, updated by the 2020 Act. Under this no-fault regime, a respondent's ability to contest the actual breakdown of the relationship has been stripped away. Look at Section 4B. You can now only dispute an application on highly specific technical grounds: if the court lacks jurisdiction, if the marriage was never legally valid in the first place, or if the union has already been legally terminated. After filing, the application must be properly served on the respondent according to Family Procedure Rules Part 6, which explicitly allows for effective service by email. By streamlining the filing process and eliminating behavioral defenses, the system prioritizes administrative certainty over dragging out personal conflicts. The successful issuance of the application triggers the first major statutory wait, a 20-week reflection period. The legislation enforces this quiet period to give the parties time to arrange their affairs and confirm they want to proceed before any conditional legal change occurs. This syllabus extract outlines the next step.
Only after those 20 weeks completely elapse can an application be made for a conditional order. For a sole application, the timeline relies heavily on the respondent returning the acknowledgement of service. In a joint application, the mechanics are tighter. Both applicants must acknowledge the notice of proceedings within 14 days to keep the joint process moving forward. Once the waiting period is satisfied and the paperwork is complete, a judge reviews the file administratively to confirm all requirements are met before granting the order. This 20-week window functions as the structural replacement for the old conciliation hearings and fault-finding debates. There is a procedural detour for clients who need legal distance but do not actually want to permanently dissolve their union: judicial separation. As shown here in Section 4E, a crucial advantage of judicial separation is that it is available during the first year of marriage, entirely bypassing the Section 3 absolute bar. The procedural steps are remarkably similar. Applicants submit a statement confirming they seek to be judicially separated, rather than proving facts. But the outcomes differ significantly. The union is not dissolved, neither party is permitted to remarry, and the court cannot utilize certain financial tools, such as pension-sharing orders. Because it avoids officially ending the marriage, this is frequently the preferred route for clients holding strict religious objections to formal divorce. It serves as a flexible tool that grants necessary legal and financial separation while leaving the marital status intact. Returning to standard dissolution, the final stage is transitioning from the conditional order to the final order. According to the procedure listed here, parties must observe another mandatory minimum wait period of 6 weeks and 1 day following the conditional order before taking this final step. To keep the process on track, this application should be made in time, within 12 months of the conditional order. If the applicant stalls and misses that window, the respondent earns the right to apply for the final order themselves after an additional 3 months pass. However, the respondent holds a critical financial safeguard under Section 10 of the Matrimonial Causes Act 1973. As indicated in the syllabus text, a respondent can formally object to the divorce being finalized on the grounds that it would cause them grave financial or other hardship. When this objection is raised, the court is obligated to withhold the final order until it is completely satisfied that fair and reasonable financial provision is in place. Note that this specific statutory shield applies exclusively to sole applications, where one party might be driving the timeline against the other's interests. The final order represents the absolute conclusion of the marriage, but it remains heavily contingent on resolving those underlying financial obligations. From the moment an application is drafted to the day a final seal is stamped, ending a marriage is an exercise in chronological precision. The entire structure rests on 3 procedural pillars: the absolute 1-year bar, the 20-week reflection period, and the 6-week finality window. This syllabus overview reinforces the essential steps required to hit these milestones, confirming the shift away from fact-finding to strict statutory procedure. The no-fault system creates a faster, less adversarial path, but it transfers the burden to legal professionals who must track these administrative deadlines flawlessly. Managing a client's expectations against a rigid, unyielding court calendar is the core challenge of modern practice. Practitioners must also remain vigilant about protecting their clients financially, utilizing caveats like Section 10 before allowing the clock to run out on the marriage. Ultimately, it is your mastery of these procedural mechanics that provides the client with legally secure outcomes. By rigorously applying these statutory requirements, family practitioners can effectively guide their clients through a difficult transition, culminating in the conclusive certainty of the final order.